welcome to EconVersations. I'm your host, Dr. Dan Sutter of the Johnson Center for Political Economy at Troy University. A legal system plays an indispensable role in a market economy, providing peaceful adjudication of disputes and enforcing contracts and property rights. And yet many proponents of markets believe that our system of civil justice is broken and in need of significant reforms. Lawsuits are out of control, according to the critics, increasing the cost of goods and services, and in some cases even keeping some products from being available at all. And ridiculous verdicts by courts threaten many businesses. Are we really awash in a bunch of frivolous lawsuits? Joining me today on EconVersations to talk about tort reform is Laura Dove, a professor of business law with Troy University and a graduate of West Virginia University Law School. Welcome to the show, Laura.
Hi, Dan. Thank you for having me. I'm excited to be here.
Well, let's get started. And before we get into any specifics about tort reform, let's just make sure we understand what is meant by civil law in general and then torts within that system.
Sure. So broadly speaking, civil law is pretty much every area of the law that's not criminal. So a lot of transactional law, and then of course a lot of dispute resolution comes to the court through civil law. So civil law basically involves civil lawsuits, I guess we could say, involve disputes between private parties, whereas criminal charges are, of course, brought kind of on behalf of society by the government, and they're kind of considered an area of that public law.
And so then within that, what are some of the different areas of civil law that would be of relevance to business and economic transactions, and how do torts fit into that?
Okay, so contracts clearly would be an area where there's a lot of import for any kind of business transactions. Disputes can arise there. But today I think the kind of key area that we'll be discussing, we'll be focusing on is tort law. And so the easiest kind of definition of a tort is just a civil wrong. And so we're generally talking about situations where a person or a person's property or some other kind of interest has been injured or damaged in some way. And so that's kind of where these tort cases arise.
And if there was a dispute between, if I bought like a washing machine from somebody and I had a dispute with the manufacturer, that wouldn't be a tort case, that would fall within the contract law?
Well, that could depend. If there was some kind of, crazy laundry machine malfunction that led to some kind of a personal injury, or let's say that it overflowed and caused a bunch of damage to somebody's laundry room. Those could be tort cases that could be brought on a product liability kind of a theory of suit. If it's just something where the machine stops working, that's a separate kind of a product liability issue, kind of more of a warranties thing, and I'm not sure that we would call that tort. So what we're really focusing on is that injury or some kind of damage to usually people or property.
Okay, and when people are talking about tort reform, we actually have both a system of federal courts in the United States and then state courts. And so sometimes when people are talking about the need for tort reform, they're not always necessarily being specific about which level of courts they're talking about. But explain for us a little bit about this difference between state and federal courts and why it's so important.
Right. So basically, under the United States Constitution, it kind of creates almost 51 separate systems of government. So, and actually more if you include the territories. So each state retains its own authority over its own legal system, over its own government, and has a lot of power to regulate things that go on within that state's borders. Then, of course, the Constitution also creates the federal government of the United States, which has its own court system. So both state courts and the federal court systems have general kind of trial level courts where most of these cases are filed. Primarily, tort cases are brought in the state courts because most of the general kind of tort law that we're talking about is based on state law. So it's possible for federal courts to hear claims even when they're being brought under state law. So there are some limited circumstances where that can happen. The big picture, I guess, probably is that most of these cases are heard in the state courts, but the federal courts do hear a fair amount of them too.
And so even though a case might be brought in, say, an Alabama civil court, it might be a national company that's getting sued in that case, right?
Oh, sure. So it's definitely possible that cases that are filed within one state really could have national impact. So the legal system of each state has an effect kind of on the economy as a whole, especially when you're dealing with a lot of these companies that do business nationally.
And so to some extent, if people were having a disagreement saying like, oh, well, we need tort reform, and others people were saying like, oh, we don't need tort reform, they could simply be referring to different states, right? And so we're looking at some states that have, what one side might think are very reasonable tort laws, and then there might be a problem with a handful of states that, could be driving this claim that we need tort reform, right?
That's absolutely true. I mean, each state has its own tort law, has developed its own body of tort law, and then each state has its own separate legal system. So there's a huge amount of variation from state to state in how these kinds of issues are handled. So you may have cases where states have not done enough as far as tort reform. Mm-hmm. On the other hand, you may be able to make the argument that some states have gone too far, but there's a huge kind of degree of difference from state to state. So
you have to be careful, and in fact, in some cases, maybe both sides could be right. There could be some validity to the both sides of this argument at the same time.
Absolutely. I don't know that it's quite as much of a black and white issue as it's often made out to be.
So let's get into some of the specific claims that are made about why we need tort reform. I mean, one of them is that we live in such a lawsuit-happy nation that we're awash in this rising tide of lawsuits and in particular tort cases, and they end up being quite distracted. There's all these resources, all these court cases get filed. What do the numbers show? Do we seem to see a big rise in the number of court cases?
So that's, there's actually some pretty interesting trends here. So if we actually look at state court cases where tort claims are filed, we've really seen a decline in the last few years. So it looks here like maybe since around 2008 or so that we're really starting to see a decline. And even before that, it looks like the numbers were remaining pretty steady. The federal courts are actually seeing an increase in the tort lawsuits that they are dealing with, and actually in civil cases as a whole. So we do seem to be looking at a couple different trends here.
Okay. Then in terms of the people in the United States being so ready, we're happy to sue each other. I mean, most Americans probably have never actually personally filed one of these court cases, right? And most Americans probably have never used the court system in this fashion, right?
I would imagine that, hopefully for most people, they can avoid having to deal with these kinds of tort cases because, hopefully that means they're avoiding a lot of different types of injuries. But right, I think the issue when we talk about do we have too many tort lawsuits or not, we can't just focus on just looking purely at the numbers or even at trends up and down. I think the real factor that is relevant is how many potential tort cases do we have where people are injured, have a good reason to sue, and then we also have to look at, of the cases that actually are filed, are these legitimate cases or not? So these are the kinds of factors that we really need to compare as opposed to just kind of looking at the numbers by themselves.
Okay, so going beyond like the numbers of suits, another thing that proponents of tort reform point to is that the torts are very costly, and I pulled a couple of numbers out of one of these reports to give a sense of why this claim of why we need to have tort reform. And this is just a number showing here the cost per person in the United States adjusted for inflation of tort cases between 1950 and 2007. And so we see that's gone up pretty dramatically, right?
Right, absolutely.
Now, and then another thing people like to point to is comparing the tort costs in the United States with other countries, and I think these are mostly European democracies. So I mean, we're not comparing the United States with Central American nations or anything, but other wealthy, developed economies and other democratic societies. And again, we see a pattern here that tort costs in the United States are higher. So how would you respond to numbers of this nature showing that the tort costs seem to be rising or that they're higher in the United States than in other countries?
Well, as far as the numbers themselves, I'm certainly not going to contest those because you are the economist, so I will take your word for these. But even looking at that, I mean, even taking that as a given, that we are seeing these costs, again, I don't know that the question can focus on, is this in and of itself a good thing or a bad thing? I think a lot of the focus has to be on, again, are these legitimate lawsuits, do they have a legitimate legal basis? If they do, then the question may then become, do we want to make it possible for some of these lawsuits to be filed? But those are claims or arguments that are being based on, is this a good reason to file a lawsuit or not? And those kinds of changes can be made through the political process, changes that can be made based on a legislature, but they're not necessarily direct kind of criticisms either of the actions of attorneys in filing particular lawsuits or of the court system in terms of how they're handling these lawsuits. A lot of that argument just centers on kind of legal liability itself and what should be the extent of it. I think another thing to focus on too, just because again we're seeing these increased costs,
you just don't know. I mean, even if you do see, I guess one interpretation of an increase in the number of suits could be that we weren't suing enough in the past. And so there could be some changes in society that have led to us filing more lawsuits, right?
Okay, so that's one thing that we had actually been discussing earlier, so thank you for saving me there and reminding me of it. Yes, so one major consideration is just looking at some of the social changes, economic, technological kinds of changes that maybe are leading to this. It may not be the case that this many lawsuits, or as a percentage of the population, this many lawsuits could never have been filed in the past. It may just be that for whatever reason they were not being filed. One thing to consider is just how much more information now is available. If you have a situation where you feel like someone has done something wrong to you, you Google it, right? I mean, so there's just so much freely available, readily available information, access to legal assistance. People might just know more about their rights now than they did previously. And then like you mentioned too, some of these changes could just reflect societal or other kinds of maybe technological changes that would make it so now that there are more reasons to file lawsuits. I mean, prior to the Industrial Revolution, there were not very many workplace lawsuits I can imagine that were filed because most people were working on their own farms and not going out and being employed in other places. Afterward, when people began to move into cities, working in factories, that's when you really saw the advent of workplace lawsuits. So that could have some kind of an effect here too, as those sorts of changes.
So it's just, there's a lot of factors that might be changing, and so you can't look at any number of lawsuits and say, well, that's too many, without getting into the details a little bit more. And I guess that leads into the next point that a number of critics make, and they make this, they like to say, well, we have too many frivolous lawsuits. But actually, when you start to unpack that term frivolous, there's a lot of nuances involved in that term, right?
That's right. I think at least we can break that down into two kind of separate arguments. I think sometimes that claim is made with the idea that there is no legal reason to file the case in the first place. And sometimes those arguments get made based on kind of the facts of the case and situations where it turns out that maybe the case didn't end up having any merit, just kind of as a matter of the evidence, what the evidence can show.
So let's expand on that first point there, because the fact that a case gets brought when somebody maybe is a defendant, a business that's getting sued, maybe feels that they don't feel that they should be able to be sued, but they might try to want to dismiss a lawsuit as frivolous because it's suing them over some element of their business that they feel that they shouldn't be able to be sued about, but that may not be true, right?
Sure, right. So that, again, takes us back to that whole idea of that's not necessarily a reason for calling a suit frivolous. The fact that you don't like the fact that there exists a legal basis for filing a suit. That, suits that are filed for those reasons you may not agree with, but if they do have that sound kind of basis in law, if there's a legal reason that would allow a plaintiff to recover, then we can't call those frivolous.
Yeah, or at least you wouldn't want to blame the legal system as it operates for that. There'd have to be a remedy through changing the law, right?
Correct, right.
But then there's also the possibility that people claim that a frivolous lawsuit might arise because there's simply nothing to it, but when we examine that, there's actually some good reasons to think that we shouldn't have a lot of completely frivolous lawsuits that have no chance of winning, and they're both like financial or economic reasons for lawyers to consider this, and then also ethical or legal reasons too, right?
Yes, yes.
So let's start with the financial incentive. Why would why a plaintiff's lawyer not want to file a suit if it really had no basis?
Okay, so there's definitely some huge financial incentives at issue, just based on how most plaintiffs' attorneys in these kinds of tort cases actually ever end up getting paid when they file these lawsuits. In many of these cases, especially when you're dealing with individual plaintiffs, the individual may not have anywhere near the money that would be necessary to pay the attorney for work on an hourly fee kind of a basis. So what is usually arranged is a contingency fee basis for the lawyer to ultimately get paid. And so what this means is that the lawyer is essentially fronting the upfront costs of the lawsuit. That can even be the filing fee. That can be, of course, all the attorney's work, the attorney's staff, even things like copying paper, travel expenses, all those kinds of things. All of those expenses are basically covered by the lawyer or the firm while the case is being filed, while the case is proceeding through the court system, and then all the way up to either a settlement or a verdict. And so what happens is if there's a settlement that's favorable to the plaintiff, or if the case goes to trial and the jury decides in favor of the plaintiff, then the attorney will basically receive a percentage of whatever the verdict or the settlement is. And then there's variations on how the litigation expenses and other kinds of court costs are taken into account. Sometimes those are taken off first, sometimes after. It just depends. But the idea is that if the attorney doesn't think that he or she's going to be successful in bringing this case, there's very little financial incentive to do that, because you're never going to get paid anything in the event that you lose.
And I think, certainly we've probably all been familiar with somebody who's tried to go to an attorney to see if they would represent them, and the attorney has said no, they won't represent them. It's probably because of this type of calculation they might be making, right?
Right. I've actually just recently read about issues that many people in Texas are having, trying to find attorneys in medical malpractice cases because of the extent of tort reform in that area. It makes it very difficult for those cases to be brought. And so a lot of plaintiffs' attorneys are just declining all but the absolute strongest cases because they know that there's very little chance of success.
But there's also, in addition to the financial incentive for a plaintiff's lawyer not to bring a weak case, there's also an ethical responsibility they face as well, right?
There is. There are a lot of sources of ethical obligations for attorneys, but really some of the key ones are rules of professional conduct within every single state. Many of these are modeled on the American Bar Association's model rules of professional conduct. And so all attorneys who are licensed to practice law are subject to these rules, and they generally provide that if an attorney does not believe that he or she has a strong basis in fact in a good faith kind of legal argument, that attorney can't file a case, can't state certain positions before the court in cases. There's got to be good faith kind of grounds for believing that there's at least some merit to the case. Similar rules can even provide sanctions and professional discipline measures for attorneys who do file cases that are frivolous.
But let's say, for instance, suppose maybe some lawyers are a little ethically challenged or whatever, and somebody does go ahead and file a lawsuit which clearly has no real basis. I mean, there's a way for the courts to handle those cases when they're first filed, right? And what's involved there?
So a couple different things, actually. First and foremost, when a case is filed, that let's assume that every single thing that the plaintiff is claiming, in that initial complaint that's filed with the court, we'll assume it's all true. If there's still absolutely nothing in the law that would let that plaintiff recover against the defendant, then the court can dismiss the case at a very, very early stage in the trial. It's up to the defendant to file what's called a motion to dismiss, but that's done really at or around the time of the defendant's very, very first response to the case. Mm-hmm. So we're talking, very, very earliest stages where these kinds of issues can be brought to light. There's a case that gets just used as a really, really common example of a frivolous lawsuit all the time, where Budweiser was sued because this guy was claiming false advertising because he had drank Budweiser and did not end up surrounded by beautiful women and having a wonderful time like he had seen on the commercials. And so he filed this lawsuit for that reason. And this is, again, if you go to many, many websites where you see advocates of tort reform, they're raising this case as, oh, this is a terrible example of abuse of the litigation process. But the thing is, that case was dismissed on a motion to dismiss, meaning at a very, very early stage. Mm-hmm. The guy even tried to appeal, and the appellate court fairly promptly issued a one-page order denying his appeal. Mm-hmm. And so in my mind, this is an example of the tort system working exactly as it should, because it's weeding out these just ridiculous cases early on in the process, and that's what we want to see.
And then in the cases where it turns out that a plaintiff can't actually prove the case, I mean, they might have the case dismissed at some point during the process, or they end up failing to win the case, right?
Sure. So there are a lot of situations where there's a solid legal reason for filing the case, but the evidence at the time the case is filed just isn't developed quite enough yet to kind of determine for sure one way or the other, whether mm-hmm. the defendant should be liable. And so, a large part of the entire litigation process is dedicated to what's called discovery, and the focus there is on allowing the parties a chance to develop their cases, obtain evidence from either side, and basically try to uncover all the relevant facts in the case that would be needed once the case goes to trial to present each side of the case to the jury. And so it's during that process, it's very possible for evidence to come out or to be discovered that shows, hey, I guess this wasn't quite as significant of a case as we thought, or doesn't have really any merit or doesn't support the plaintiff's side. And so it's possible at that later stage for a case to be disposed of by a judge where it doesn't need to go to a jury because there just isn't really any kind of legitimate remaining argument. And
it seems quite wrong to sort of look at a case that in hindsight, when we see when all the facts were sort of uncovered, it turned out that case wasn't so strong. And I mean, there's no way we could know necessarily when the case is filed that one ended up being frivolous. But I mean, it's assuming a level of knowledge that's just impossible to assume that any court system could have, right?
Absolutely. So you may have a very good reason for filing a lawsuit, for thinking that you have a legitimate claim, but you may not even have any access to the evidence that you need without filing that case and without moving through that discovery process.
Well, turning out to an example of what many people consider to be a prime example of a frivolous lawsuit. It is a suit from about 15 years ago. But this lady here is Stella Liebeck, and she sued McDonald's over burns she received from hot coffee, the McDonald's hot coffee lawsuit. And she ended up being awarded, I think, initially to $2.9 million. And this case is used for a lot of different reasons by advocates of tort reform, one of which is to point to these quote outrageous awards is in cases like this. But although people often report these awards when they're first handed down by the jury, those awards don't always stand up, do they?
No, they don't. As a matter of fact, in this particular case, that original jury verdict that's widely reported as kind of the end of the story really was nowhere near what was actually recovered in the case. The trial judge originally reduced the $2.7 million verdict down to $480,000. That was on the punitive damages aspect. She was also awarded $200,000 by the jury to cover her medical expenses and her other kinds of actual damages, just to kind of compensate her for her injuries. And that that verdict was then reduced by $160,000 under the state's comparative fault rules. Because one thing that's also never or very rarely reported is that the jury actually found the plaintiff here 20% at fault for her injuries. So her verdict, the verdict was reduced in that amount as well.
And this, again, another thing that people point to is that this seems to be a frivolous lawsuit. I mean, in the grounds that, like, oh, well, everybody knows coffee's hot, and if you spill it on yourself, it might cause a burn, but you shouldn't be able to sue over something like that, over hot coffee. And so you see we have a billboard there that's sort of indicating how this is used as a poster child for the need for tort reform. But there's more details of this story, right?
Yes, there is. There's quite a bit of background here. So first of all, the evidence that came out at trial established that McDonald's was serving their coffee about 30 to 40 degrees hotter than every other restaurant in the area. And not only that, McDonald's itself had actually commissioned a survey of all the local restaurants, or may have been that particular franchise, but of all the local restaurants who also served coffee. And it turned out that none of them served coffee anywhere near as hot as McDonald's did. McDonald's knew this, continued to serve the coffee hot. A representative from McDonald's at trial admitted that the coffee was not, quote, not fit for consumption when sold. There was a significant amount of expert testimony on the dangers of serving coffee at that temperature, and 700 people had been burned, notified McDonald's of this and kind of complained about the temperature of the coffee over a 10-year period before this case. So it's not an issue of the coffee being hot, and of course we all know that coffee's hot. The issue here is that we're talking about an extreme temperature, really, that's far more dangerous and far more potential for injury there than I think pretty much anybody would expect.
And Ms. Stella even offered to settle for much less than $2.9 million before bringing the case, right?
She did. Before she even retained an attorney, she had initially offered to settle the case for $20,000. All she wanted was to have her medical expenses covered and to have some of her daughter's lost wages covered that were needed to care for her. And McDonald's would never offer any more than $800.
Well, very fascinating. Any final thoughts in terms of whether about tort reform, the need for tort reform?
I guess my feelings on tort reform are mixed. I mean, for all the reasons that we've talked about today. So I can't really feel comfortable walking away saying, oh, we need more tort reform or we need less tort reform. What I think we need more of is a focus on a balanced and just more of a balanced discussion, and really a recognition that there are a lot of complex issues in this debate.
Well, thank you very much, Laura. Thanks for coming on the show. And thank you for joining us. Join us again next time for another EconVersations.